An 8-1 Supreme Court decision just dropped that changes everything about when police can search your phone during an arrest. And if you don't understand what just changed, you could hand over evidence that destroys your life without ever being required to do it. Before we dive in, I need you to subscribe right now. Why? Because this ruling affects every single person who carries a smartphone in America, and 90% of people will never hear about this decision until it's too late. Click that button, because what I'm about to reveal could be the difference between protecting your privacy and giving police unlimited access to your entire digital life. Here's what just happened. On January 15th, 2026, the United States Supreme Court issued an 8-1 decision in Commonwealth v. Rodriguez. When 8 justices agree on a digital privacy case, you need to pay attention because it means something fundamental just changed in how the Fourth Amendment applies to your phone. The case started simple enough. Maria Rodriguez was arrested for shoplifting at a mall in Virginia. During the arrest, police asked if they could search her phone for evidence. Rodriguez said yes, but here's the critical part. She was never told that she had the right to say no, and she was never told what police would actually find if they searched it. Inside her phone, police discovered text messages about a completely different crime, a drug sale from 3 weeks earlier. Rodriguez was charged with felony drug distribution based entirely on evidence from a phone search she consented to for a misdemeanor shoplifting charge. Here's the question the Supreme Court had to answer. When police ask to search your phone during an arrest, what exactly do they have to tell you about your right to refuse? Now, here's the mistake that 95% of Americans make during police encounters. They think cooperation means saying yes to everything. They think refusing a search makes them look guilty. They think police will treat them better if they just hand everything over. And that thinking destroys more lives than any other single mistake in the American legal system. Let me be clear about something right now. When a police officer asks to search your phone, they are not making conversation. They are conducting what's called a consent search, and everything changes based on whether you understand what you're actually agreeing to. Most people have no idea what's legally at stake when they say, "Sure, go ahead, I have nothing to hide." You're not just giving them access to your photos and texts. You're giving them access to your location history, your search history, your financial apps, your medical information, your work communications, and every conversation you've ever had with anyone about anything. The Fourth Amendment to the Constitution protects you from unreasonable searches and seizures. But here's what most people don't understand. If you consent to a search, the reasonableness standard disappears. Police don't need probable cause. They don't need a warrant. They don't need reasonable suspicion. They just need your permission. And until this Supreme Court decision, police had no obligation to explain what your consent actually meant. In Rodriguez, the court looked at a simple question with massive implications. Does the Fourth Amendment require police to give you meaningful information about what you're consenting to when they ask to search your phone? Justice Jackson wrote the majority opinion, and she made it clear, consent is only valid if it's informed. You cannot make a knowing waiver of your constitutional rights if you don't understand what those rights actually protect. The court established what they called the digital consent standard. Before police can search your phone based on consent, they must inform you of 3 things. First, that you have an absolute right to refuse the search. Second, that anything they find can be used as evidence against you for any crime, not just the one you're arrested for. Third, that your phone contains far more personal information than any physical container they could search. Justice Jackson wrote, "The phone in your pocket contains the most intimate details of your life. Your locations, your relationships, your thoughts, your fears, your medical history, your financial situation. No reasonable person can consent to a search of such comprehensive personal data without understanding the scope of what they are surrendering." 8 justices agreed. Only Justice Thomas dissented, arguing that existing consent standards were sufficient. So what does this mean for you? It means that as of January 15th, 2026, police encounters with phones just got more complicated. But it also means your rights just got stronger, if you know how to exercise them. Here's what the new standard looks like in practice. If police arrest you and ask to search your phone, they must tell you, you have the right to refuse this search. Anything we find in your phone can be used as evidence against you for any crime. Your phone contains extensive personal information, including your locations, communications, and private data. Do you consent to this search knowing these facts if they don't give you this information? Any evidence they find from your phone becomes much harder to use in court. But here's what the Supreme Court did not say, and this is critical. They did not say police can never search your phone without consent. They did not say police need a warrant for every phone search. They did not say your phone is completely protected during an arrest. The ruling only applies to consent searches. Police can still search your phone in several situations. If they have a valid warrant, if there are exigent circumstances like preventing destruction of evidence, if they're searching for weapons during a lawful arrest, or if you're crossing international borders. The decision also doesn't apply to data police can see without unlocking your phone. If your phone displays notifications on the lock screen, those are still fair game. If you have apps that show information without requiring a password, police can still observe that information. And here's something that's going to surprise people. The ruling doesn't protect you if you voluntarily unlock your phone and show police something. If you pull up a text message or photo to show an officer, you've just consented to them seeing that information, and it can be used as evidence. Let me give you 3 real-world scenarios so you understand how this plays out. Scenario 1. You're arrested for DUI. Police ask to search your phone looking for evidence that you were texting while driving. Under the new standard, they must explain that you can refuse, that anything they find can be used against you for any crime, and that your phone contains extensive personal data. If they find evidence of drug activity from last month while searching for texting evidence, that drug evidence is still admissible because you gave informed consent to the search. Scenario 2, you're arrested for assault after a bar fight. Police ask to search your phone for videos of the incident. They give you the required warnings. You say no. They cannot search your phone based on consent, but they can still get a warrant if they have probable cause to believe evidence of the assault is on your phone. Scenario 3. You're arrested for shoplifting. Police ask to search your phone. They don't give you the new required warnings. You say yes anyway. They find evidence of unrelated drug sales. Your attorney can now argue that your consent was not informed under the Rodriguez standard and that evidence should be suppressed. But here's the part that's going to shock most people watching this. Even with the new Rodriguez standard, most evidence from phone searches will still be admissible in court. Why? Because most people will still say yes, even when they understand their rights. The Supreme Court didn't make phone searches illegal. They made uninformed consent illegal, but informed consent is still consent. If police explain your rights clearly and you still agree to let them search your phone, whatever they find can still be used against you. This is why understanding your rights isn't enough. You also need to understand the practical consequences of exercising those rights. If you refuse a consent search of your phone, several things might happen. Police might get frustrated, but that's not your legal problem. They might detain you longer while they try to get a warrant, but that detention has legal limits. They might try to pressure you by suggesting that refusing makes you look guilty, but looking guilty is not a crime. What they cannot do is punish you for refusing consent. They cannot arrest you for saying no. They cannot search your phone anyway just because you refused, and they cannot use your refusal as evidence of guilt in court. But here's what you need to understand about the practical reality of exercising these rights. Most people who refuse consent searches are not doing it to hide criminal activity. They're doing it to protect their privacy, their relationships, and their personal information that has nothing to do with whatever they're arrested for. Your phone contains text messages with your spouse, photos of your children, medical information, work communications, financial data, and personal conversations that could be embarrassing or damaging if taken out of context. Even if you've never committed a crime in your life, you have legitimate reasons to keep that information private. The Rodriguez decision recognizes that reality. It acknowledges that phone searches are qualitatively different from searching your pockets or your car because phones contain the digital equivalent of your entire private life. Here's what this means going forward. Police departments across the country will need to retrain officers on the new consent standards. Prosecutors will need to be more careful about how they use evidence from phone searches. Defense attorneys now have a new avenue to challenge evidence that was obtained through uninformed consent. But the bigger impact is on you. You now have stronger legal protection for your digital privacy, but only if you understand what that protection actually means. The Supreme Court can't force you to exercise your rights. They can only make sure you know what those rights are when it matters. If you choose to consent to a phone search after receiving proper warnings, that's your choice. But it should be an informed choice, not a decision made out of confusion or fear. Here's my final point, and this is the most important thing you'll hear in this entire video. The Rodriguez decision doesn't change the fundamental reality of police encounters. Officers still have jobs to do. They still need to investigate crimes. They still need to gather evidence. What Rodriguez changes is the information balance. It makes sure you understand what you're giving up when you say yes to a phone search. It makes sure your consent is meaningful instead of just reflexive cooperation. But consent is still consent. Cooperation is still cooperation. And evidence is still evidence. The law doesn't judge you based on what you intended to do or what you thought you were agreeing to. It judges you based on what you actually said and did. The Rodriguez standard makes sure you have better information when you make those decisions, but it doesn't eliminate the consequences of those decisions. Every word you speak to police is potential evidence. Every permission you give can be used to build a case against you. Every right you waive is a protection you lose. The Supreme Court just made sure you understand what you're waiving when it comes to your phone, but you're still the one who has to make the choice. Remember, this is educational information about your constitutional rights. This is not legal advice for your specific situation. Laws are complex, situations are unique, and the stakes are real. If you're facing criminal charges or dealing with a police investigation, consult with a qualified attorney who can give you advice based on your specific circumstances. The Rodriguez decision is a win for digital privacy and informed consent. But it's only a win if you understand what it means and how it affects your choices during police encounters. 8 Supreme Court justices just made sure police have to explain your rights more clearly. Now it's up to you to decide how to use that information.